Perfect. Okay, so let's start the event. So welcome everyone, either both in person and online, to this hybrid policy dialogue, assessing the Union's rule of law, lessons from the 2025 Shadow Rule of Law report. My name is Javier Carbonell. I'm a policy analyst here at the EPC. As an EPC member, it's my pleasure to welcome you all. I'll just say, the policy dialogue is a collaboration, of course, between the CEU Democracy Institute's Rule of Law Clinic and the European Policy Center project Connecting Europe. I'll just say a couple of words about Connecting Europe, and then I'll leave the floor for the event. So it's a project funded by Stiftung Mercator that has been hosted at the EPC since 2017. And we bring together a network of more than 65 organizations from over 14 European countries. Our goal is to bring the policy debates to make them more transnational, and so to connect civil society organizations from all across Europe with policymakers here in Brussels and vice versa. And we hope that by including more local voices, the debates in Brussels can be more diverse and open. We do this by co-organizing events in Brussels, such as this one, by offering advice to both civil society members and policymakers on how to collaborate more effectively, and by actively contributing to a debate on how to strengthen civil society organizations in the European Union. Today's policy dialogue is the second time we host the launch of the Shadow Rule of Law report here at the EPC. I've been having the last year's report at my desk for the whole year. It's an amazing report, and this year's report is even better. So I welcome you everyone to check it. You have it all in your seats. And it's really an important contribution. The event will last around an hour and a half, and then there's a bit of sandwich for everyone if you want to talk and continue the discussions there. And so thank you very much for joining us. Thank you. And I leave the floor for Dimitry.
Let me serve as the second introducer. So CEU still exists in Hungary a little bit, although we had to evacuate ourselves. We left. But there's a tiny institute which is called Democracy Institute, and this is where I had the rule of law. My name is Dimitry Kochenov. So the clinic that is presenting the report today is one of the flagship projects of the rule of law working group at CEU, and we hope that we can make a valuable contribution, even though we find ourselves obviously in a very dramatic and extremely unfriendly environment if you take rule of law seriously.
Thank you. Good afternoon. My name is Grabowska-Moroz. I coordinate the Rule of Law Clinic at CUDI, still in Budapest. And this is the second time the clinic, together with a group of legal scholars, prepared a report which tries to assess how Article 2 is implemented at the supranational level. We try to follow the original structure of the Commission's report. So we look for the main developments in the field of access to justice, anti-corruption framework, media freedom, and system of checks and balances. We also decided to follow the Commission's step to broaden the report, and we also included the internal market dimension of the rule of law into our report. Despite the fact we have not witnessed any treaty changes in the last year, we were managed to track some interesting developments. And to give you an example, the Commission's decision to request the opinion of the Court of Justice to assess the draft agreement on accession to the ECHR is one of such important developments, which can actually make Article 6 obligation a real law in practice. At the same time, access to the court in the EU remains one of the major issue. Medal case, so a complaint introduced and submitted by 4 International Judicial Association, which was rejected by General Court, will be now reviewed by the Court of Justice, and we will be able to witness whether the court, access to the court, so a fundamental element of the rule of law, can be actually materialize in the EU. When it comes to the anti-corruption framework, in my opinion, it's one of the biggest challenge in the EU Shadow Rule of Law report. This framework is based on a very complicated linkage of interinstitutional agreements, some very internal, not really enforceable rules, and even the latest major developments. So establishment of this interinstitutional ethical body, it did not happen in practice. So we still cannot see any real improvements in this field. When it comes to the media freedom, the major developments from last year, so introduction of European Media Freedom Act or anti-SLAPP directive, is still awaiting the final implementation by member states. But here, the role of the Commission will be absolutely crucial to review how the EU law is being implemented, how it really becomes a practice at the domestic level. Another cornerstone of press freedom is access to information. And it seems that it's a real problem at the EU level, which was confirmed by the Court of the General Court in Stevie and New York Times versus Commission. Also, the field of enforcement of the rule of law by the EU institutions seems to face important challenges. So the case that most probably the EU funds will be unfreezed, despite the fact that there were no real improvements at the domestic level. The same applies to the closure of Article 7 last year. And this is exactly the field where the legitimacy of the EU actions can find their sources and can be improved because of our Article 2 being directly applicable also to the actions of the EU law. At the same time, lack of transparency and also lack of accountability remain the main issues when it comes to the migration management in the EU. Also, civil society seem to be facing really important challenges coming even from the EU institutions. So there is a chance that the EU strategy, which is now under preparation by the Commission, might be a chance for the civil society to actually improve the situation also at the EU level. Finally, in the context of the internal market aspect of the rule of law, we noticed some really troublesome developments when the EU digital policy is facing challenges coming from the geopolitical factors, which tend to undermine the effectiveness of the enforcement of the EU-own legislation. As I mentioned in the very beginning, the very aim of this report is, first of all, to improve the situation of the rule of law in the EU, and by that to enhance and strengthen the legitimacy of the EU actions in this respect. I think it's an important element in conducting such a discussion. So I'm very pleased that you join us today in this debate. And now I'm going to pass the floor to Joelle Grogan, co-editor of this report, who's going to moderate the further discussion today with our guests on the topics covered in the report. Thank you. Thank you.
Thank you so much, Barbara. First, can everyone hear me? Okay, I have some quite confident nodding. That's great. So what I'm going to do first is introduce everyone on the panel before we get into the Q&A. So joining us online, we have Tineke Strik, who is a member of the European Parliament for the Greens and EFA. We then have Florian Geyer, who is head of unit at the Rule of Law Unit in the European Commission. We have Dr. Sarah Gonti, a postdoctoral researcher in UC Leuven and a JST candidate at Yale Law School. And we have Professor Laurent Pech, who is co-director of the Rule of Law Clinic at the CEU Democracy Institute. To answer first the burning question for everyone in this room, yes, I am a 95-year-old smoker. I just have fantastic skincare. So I'm hoping, beyond hope, that my voice lasts for the next hour, but we're going to find out. But the point of this panel is not going to be giving a lot of lectures to you. We're going to drive it mainly in terms of a Q&A. So I'm going to open up with a few Q&As first. to the panel, both here and online, and then I'm going to open it up to the room. I realize that my voice sounds like I'm weak and I'm suffering, and I am, but I will be very, very, very strict on all degrees of timing. So if I hear something that sounds like an opinion or a comment, I will cut you off. So first question, Laurent, please save me from my voice. Why on earth do we do this report?
Thank you, Dr. Grogan, and thank you for suffering on behalf of the rule of law. Your sacrifice is noted and appreciated. So what do we have? A report dedicated to the EU's performance on the rule of law front. So perhaps before I get to that point, actually just a brief reminder that the annual rule of law report was not part of the initial rule of law toolbox 10 or 15 years ago. He came actually from mostly political actors, and essentially in 2019 it was decided that there was a need. I mean, I'm not going to go into the pros and cons of the need of the annual rule of law report, but it was decided that we were going to adopt a so-called annual rule of law report, first edition, if I remember well. I'm just getting old as well. It's 2020. And from the start, it was decided that the EU institutions, and mostly first and foremost the Commission, would focus on the situation in EU member states. And there was no discussion at all about an EU chapter as part of the annual rule of law report. In fact, the idea of an EU chapter came from the European Parliament. In fact, if to mention one name, I think Sophie in 't Veld can claim the credit for this idea. Some MEP suggested that we needed to subcontract this EU rule of law report to the Venice Commission. Professor Bard and myself had some concerns about this idea, but since this wasn't done, we said this would be a good task for the newly funded EU rule of law clinic to do. And currently, there's still no EU chapter, and I don't think there is a political will for an EU chapter. What we have seen in terms of changes is that in addition to the EU member states, now you have 4 candidate countries added to the 27, and a transversal report I forgot to mention, but which is about the situation at member state level. So to go back to the added value or the need for this report, essentially, I'm afraid we are now we're living through a global rule of law recession, and the EU, through its action and inaction, may contribute to this rule of law decline and regression. So it's not all about bad news. The EU can also, has historically been a positive force for the rule of law, but sadly, we're also seeing a number of arguably violations of EU rule of law requirements by EU institutions, and I think it's important to document them. We are reaching a stage where essentially the rule of law, I'm afraid, at least I'm speaking in a personal capacity, the rule of law is both threatened at the national, local level, and not necessarily enforced at the supranational level. So essentially, to put it in a different way, the report is about holding the EU to account and assess its rule of law performance, following, as Barbara was describing, the kind of the structure of the report itself, to make it easier to see where the EU is adding value in upholding the rule of law, and areas where, arguably, at least according to the experts consultant for this report, the EU, through its action, but also it's very important to emphasize inaction as well, can lead to actually weakening or, in fact, violating what has been described as the EU's rule of law ecosystem. So I think this report is needed, and it's important. I would say just one last point. My personal worry is that we are seeing an increasing gap between EU rule of law rhetoric and EU's action. So I think by documenting the areas where this gap is increasing, we are participating at all levels to actually defending the rule of law. And we're defending the rule of law, as I said, sometimes against the EU. But obviously, I'm simplifying because the EU is not a monolithic institution. And even within EU institutions, You have also some divides and tensions when it comes to upholding and defending the rule of law, but I'm not going to go into details. If you have a rule of law gossip questions, you can always ask me. I have good sources. So thank you very much.
I won't ask you about the gossip yet, but Sarah, let's come to you as one of the contributors to the report. What have you found have been some of the emerging issues over the last year?
Speaking of the... Can you hear me now? Excellent. Thank you, Joelle. Speaking of the emerging issues, or rather the ongoing issues, rather than emerging issues, I would like to focus on the question of migration. I think it was actually one of the motivation of the rule of law report, also to kind of broaden our understanding of the scope of the rule of law, right? And when we read the report of the Commission doesn't really cover the issue of migration, why there are a lot of rule of law issues over there, and why migration encapsulates one of the EU's greatest legal and moral failures in terms of the respect of the rule of law. And it was the case last years, but also still this year, right? And we are speaking of hundreds of thousands of migrants pushed back at EU borders, like more than 100,000 in 2024, often with Frontex involvement, an EU agency. We are also speaking of more than 32,000 men, women, and children who, since 2014, drown in the Mediterranean. Why no EU rescue mission is longer in place? Irene mission hasn't saved any migrants since its creation in 2020. We are speaking of hundreds of thousands of migrants violently intercepted by the so-called Libyan Coast Guard, guided by geolocation data shared by Frontex again. And if these migrants survive, they are detained in detention centers where crimes against humanity happens. This is not me saying it, but a UN fact-finding mission saying it. And these centers are run by the Libyan Central Directorate for Combating Illegal Migration, the biggest recipient in Libya of EU funds, together with the so-called Libyan Coast Guard. And meanwhile, thousands of migrants are suffering inhuman treatment, whether in Turkey or in Tunisia, among others, triggered by so-called informal deals and with financial and material support of the EU. So we are here standing at the heart of the rule of law, and we see, in a way, like the EU tearing it apart. And so now the question is, so what's new? Like, what are the emerging issues? And there is nothing really new. Yeah, we can speak about like some proposals, pending, etc., but just the situation has worsened in some sense. More torture, more dead, with more deals and more EU money, right? So this is what we are speaking about. We are speaking of informal migration deals, which have multiplied over the last year, deals with Tunisia, Egypt, Jordan, Lebanon, Mauritania, informal deal which bypass all the procedural safeguards, meaning no substantial guarantees, no robust independent human rights monitoring on how these states implement migration control measures leading to human rights violation. And in the meantime, more and more money, EU money, is invested into these countries for migration management, whether under these informal deals or not. There is no formal deal between EU and Libya, just a formal deal between, an informal deal between Italy and Libya, but the EU has committed to support this deal. And so there is, in the way this money is spent under the Global Europe instrument, there is no systematic human rights assessment either, whether it's ex ante and ex post. And now the proposal for the next EU long-term budget, 2028-2034, depicts a situation even worse in terms of accountability of EU funds into this migration, externalization and migration management in third countries. And finally, and I'm finishing here because I say that Joelle is probably, no, okay, this is great. So Frontex, of course, is a core issue of when we are speaking of the EU rule of law respect, and Frontex has been involved in a human rights violation report by the EU Anti-Fraud Office itself, right? And the problem with Frontex is that it's only accountable before the European Court of Justice, and so far, every single action in damages and action of failure to act has failed before the court, meaning that Frontex hasn't been found accountable at any point before the European Court of Justice. But, and I will finish with that, there is a kind of a glimmer of hope because there are 3 cases pending, 2 cases in appeal before the Grand Chamber and 1 case before the General Court regarding the practice of Frontex sharing geolocation data to the Libyan Coast Guard, which will be ruled like on the substance for the first time. So hopefully next year we will be able to report some progress about Frontex accountability, but this is to be seen.
Migration, my gosh, I'm so sorry. Migration is quite a really highly topical and severe issue across many countries in the EU. But Laurent, how many other ongoing or emerging issues have you identified within the report?
So sadly, there's quite a few. I mean, I can just, I'm not going to repeat what has been said already, but perhaps one of my main concerns, to use one of the most repeated words in EU rule of law reports, is that what I'm seeing is an increasing politicization of the EU's rule of law toolbox. And by politicization, I mean essentially that legal and technical assessments are interfered with on the back of political and geopolitical considerations. So what I mean by that is when EU institutions apply the toolbox, internal sound technical and legal assessments are overruled by the political masters for reasons which have nothing to do with the objective assessment of the rule of law situation. I can multiply examples. In fact, that's going to be my next incoming working paper for the CEU Democracy Institute. I'm just finishing an article on the use, misuse, and non-use of the EU's rule of law toolbox. And then you can easily multiply, you can evidence that actually the lack of connection between some of the assessments made by the EU and reality on the ground, including reality as described in courts' judgments. There is a disconnect increasingly, and the disconnect can only but be explained by non-legal factors. So this means not only in terms of unlocking, for instance, access to EU funds on the back of non-existing judicial reforms, it means also not initiating actions on the back also of misleading or incomplete legal assessments. And this affects both monitoring tools and enforcement tools. And in fact, there is a section in this report where essentially we summarize the latest 12 months. And this is really worrying for me because actually, to a large extent, this is directly undermining the legitimacy, credibility, and authority of the EU as a rule of law actor, and indirectly, in fact, making it easier for anti-rule of law actors to actually criticize the EU for lack of consistency. This lack of consistency is not when the EU does act, actually, in respect of rule of law violators, but quite often when it looks the other way or stops procedures on the back of just simply unconvincing assessments. So I think this is one of the most worrying trends. And if I had to add one, and this is not simply affecting the EU, actually, we're seeing, as I was mentioning, global rule of law recession, but what we're seeing, for instance, in the US most recently, we're seeing lawlessness being officially, openly embraced by public authorities. And one of the concrete consequences of this is that we are seeing rulings, including injunctions by judges, simply openly disregarded. And I'm not talking simply national rulings, but the rulings of both European courts are increasingly non-complied with. And it used to be that national authorities disregarding or violating rulings would actually try to explain to us or justify, or will try to justify or disguise their non-compliance. But what we're seeing now is that they openly non-comply, and they're saying they justify this in the name of the will of the people, blah, blah, blah. And here, I think the EU has a crucial role to play, the Commission especially, as the guardian of the treaties. And yes, the annual Rule of Law report does mention non-compliance with the European Court of Human Rights rulings, but not enough work is being done regarding non-compliance with the rulings of the Court of Justice. We are at the stage also where the entire EU system of judicial remedies is under threat, undermined, because the two ways of accessing the Court of Justice, I mean, you have essentially three ways of bringing rule of law cases to the Court of Justice. Normally, you would expect infringement actions to be the most decisive, and they are. And then we used to argue that we have a complete system of remedies in the EU because national judges can also refer questions, except what we're seeing is that national judges referring rule of law questions are subject to formal or informal harassment. And then third option, but which is not working and actually is part of the report, we are saying that in a situation where the Commission doesn't bring infringement, national judges are being targeted when they bring rule of law question, then we're only left with direct annulment actions. And here we're facing a structural rule of law gap in the EU system of remedies. The court's too strict interpretation of legal standing rules on the basis of a legal test which was devised in the early 1960s and which we think is simply needs to be adjusted to the post-Lisbon constitutional framework and the case law of the Strasbourg Court. So EU accession will eventually remedy to this disconnect in terms of access to the Court of Justice, but that's going to take a few years. And so essentially we're in a bad place because rule of law violations it's difficult to bring them to the attention of the Court of Justice. In the case of the medal litigation, which was mentioned by Barbara, this is something I would pay attention to if you're interested on rule of law matters. Obviously, Florian might disagree, or does not have, in fact, to agree or disagree with my assessment of whether Poland's recovery plan was disregarding or not disregarding the case law of the Court of Justice. But here, this is a concrete example of essentially gaps in access to the Court of Justice, where you have EU institutions arguably disregarding the case law of the Court of Justice for political reasons, and then a national judge subject to sanctions if they submit references on the same topic. And then we're left with an annulment action against EU measures, except the action was dismissed on legal standing grounds. I'm not going to go into the details of legal standing assessments, but the case is now pending before the Court of Justice, and this is essentially the first historical opportunity for the Court of Justice to assess whether legal standing rules, or at least the legal standing test, must be adjusted in a situation where the rule of law is has been arguably violated by national authorities with the support of EU institutions, at the same time in a context where the preliminary ruling jurisdiction of the court has been structurally and legally undermined at the time of when the case was lodged, meaning that the only way of challenging the decision was direct annulment action. But if this route is blocked, and it has been essentially ineffective regarding Frontex, for instance, then it means essentially that rule of law violations can survive in the EU legal order in the absence of effective access to the Court of Justice. I don't know whether I've been a bit too technical, but essentially my main point is we need the Court of Justice to think carefully about whether it should not widen or at least adjust legal standing rules when it comes to association of judges trying to defend the rule of law in this instance against EU institutions. Because if not, then we have a structural gap in the system. So thank you.
Laurent, I want to pick up on one issue that you raised there. So this report highlights quite a number of severe issues. We've heard already about the critical issues in the area of migration and also in terms of access to justice. Are we not undermining the cause by producing a report like this that is very, very critical, that this just gives fodder to states that are themselves backsliding?
My experience, no matter what you do, whatever you say or do, they will always find a way of essentially portraying in a misleading way. So essentially, I think what is most important, so we shouldn't be adjusting our course of action. We should have a principal course of action, and we should not pay attention to the ways, whatever, or criticism of the EU on reasonable, good faith criticism of the EU is going to be portrayed or misportrayed by anti-rule of law actors. I think we need to make sure that the EU is not engaging in double standards. When it comes to legal standing, actually, there was a recent opinion of an EU Advocate General stating explicitly, and in a rule of law context, that the lack of effective access to the Court of Justice is suggesting double standards compared when one views actually the court's own case law regarding access to national courts. So I think what we need to worry about is the authority, credibility, and legitimacy of the EU. We want the EU to be a pro-rule of law actor acting in compliance with its own rhetoric. When the EU does not comply with its rhetoric for non-legal reasons, it's not us undermining the EU, it is the EU institutions themselves. And I think I'm happy to do both, being a friend, a critical friend of the EU institutions, and also at the same time being very critical of those actively and proactively undermining the rule of law at the national level. One doesn't prevent the other. And I think the bottom line is you should always be guided by your principles and not adjust your principles on the basis of short-term considerations, because in fact, by doing that, we'll be doing exactly what we are criticizing EU institutions for, which is essentially acting, sometimes looking the other way for reasons of political convenience. So I think we can be a critical friend of the EU while being essentially showing no mercy when it comes to national authorities harassing judges, violating their constitutions, systematically disregarding judgments of the European Court of Human Rights and the European Court of Justice. I know I can do both, and I know many of you can do both as well. So thank you.
Could I ask the same question to a person who I hope is not a critical friend of me, Sarah?
Am I?
How are you?
No, I don't have much to add to what Laurent just said, but of course, like what undermines the rule of law is what is highlighted in the report and not the report itself, right? So I think it's very important to basically bring to light a lot of issues that we have underlined in this report. And that's interesting that Laurent was speaking about double standards, because again, coming back to the migrant and migration issue, like there has always been a double standard for migrants, and here it seems like there is no standards anymore. So this is really what the report tries to underline here. And what is interesting is that I really believe that the report, but like is part of other, I would say, creative initiatives trying to really like denounce these rule of law issues, but also try to make like national officials, but also EU officials accountable. And here we see, for instance, that national and international criminal law has been used in a very powerful way, including by Omar Shat, who is one of the contributors of the report, with his association Frontlex. He has brought before the International Criminal Court more than 120 EU officials suspected of crimes against humanity against migrants. So the website is EUcrimesagainsthumanity.eu or crimesagainsthumanity.eu. You can check it, but I think this is a very important initiative when it comes to accountability and respecting the rule of law. And at national level, we have seen Italian judges, like considering that you can, as Italian officials, engage your criminal responsibility in case of pushbacks, especially pushbacks to Libya, which is obviously not a safe country. So here we really see that they are like trying their initiative, like trying to use basically the law in order to make officials accountable regarding the issue of the rule of law at national level, but also at EU level, which is a very important aspect of it.
Let's turn to Strik online. Tineke, what issues would you identify either at EU level or in terms of enforcement and monitoring of the rule of law in the EU?
Thanks a lot, Joelle. Good luck with your with your vote. It's going well so far. I think the main issue, if it comes to rule of law, is indeed the enforcement itself. What you see is that the Commission has come closer and closer to the member states since the last maybe 10 years already. But it's also very much threatening the autonomous role of the Commission as an enforcer, as a guardian of the treaties. At a certain moment, the Commission aimed to become more political. And I think in the end, that has led to this, what Laurent also said, the politicization of the instruments that the Commission has in order to enforce compliance with the rules. And I think this is really leading, you see it everywhere in all policy areas, to a certain level of impunity, which also, of course, has a very wrong example for other member states who think, okay, I can get away with not respecting the rules. And I think on the rule of law as such, you see a very ambivalent attitude of the Commission. I mean, I'm rapporteur on Hungary. So there you really see that there are infringement procedures being taken. There is money frozen, but oftentimes it comes at a quite late stage. There's no request for interim measures, so no speedy review by the Court of Justice. The freezing of the funding is sometimes also, arbitrary, especially if you look at the defreezing of 2 years ago because of the judiciary that, should be meeting the milestones on independence. And we saw it, of course, only further deteriorating since then. The Commission is a bit opaque in when and why it takes certain decisions if it comes to enforcement. And that's an undermining in itself, I think, because you need predictability that if certain rules are violated, you can count on certain actions and also persistence. And of course, it's also the Council that has a role in rule of law issues. If you look at Hungary being part of being subject to the Article 7 procedure since 7 years and no action being taken, we will be voting in the Libe committee on our new interim report, our second interim report on Hungary. And there we also conclude that this inaction leads to the Council itself violating Article 2 of the treaty, completely neglecting its role in order to ensure the rule of law. And if I may just mention one specific thing, referring to what Laurent says about access to the Court of Justice, what I find striking is also the fact that this Supreme Court, the Curia in Hungary, has designed a uniformity complaint panel Yeah.
Sorry, we briefly lost you. So if you could repeat the very last point.
Yeah, well, to give a very concrete example on the uniformity complaint panel that the Hungarian Supreme Court, the Curia, has designed, which means that the Curia itself is interpreting a Court of Justice ruling, saying like, should we follow it or not, or should we keep with our own interpretation? And this is not only a big threat for the primacy of EU law itself, but also has a huge chilling effect on national judges who want to request for preliminary ruling. So I would really want to see then, in these kinds of cases, a big sense of urgency from the Commission, immediately taking action in order to show where it stands. And apart from rule of law, just a few sentences. I really find it good that this report also integrates the asylum and migration issues in this rule of law report, because oftentimes it's discussed in a separate way. And there you also see how important it would be that fundamental rights are also part of the rule of law report. There, the enforcement is completely lacking, completely lacking. Funding is not subject to conditionality, no infringement procedure at all. And then even if you talk about the core issue, for instance, giving access to an asylum procedure for migrants, as Sarah just explained in detail, and it's even going further. If a member state says, openly demanding from von der Leyen that they will not offer access to an asylum procedure, von der Leyen is accommodating them. And this means that we cannot expect anything from the pact, I think, if this attitude stays, because member states know that no matter what they do, there will be no sanctions at all. And my very last point is indeed on the externalization, where it's very clear that the treaty, Article 21, obliges the EU in its external actions, including funding, to promote democracy, rule of law, and fundamental rights. Well, the opposite is the case, because you really see, due to the lack of conditionality on rule of law, it's only the conditionality on preventing migrants to travel, the repression is only increasing towards asylum seekers and refugees, but even also towards the own citizens, because it's oftentimes autocratic regimes that conclude such deals. So we are completely neglecting our own obligation to make sure that external actions are in line with our treaty obligations and furthering democracy and rule of law instead of undermining.
Tineke, just staying with you, what do you think are the kind of barriers to self-assessment or even independent assessment of rule of law at EU level?
You mean own assessment by the European Commission? Well, I think the more you see this politicization, the more difficult it becomes if it's the Commission only that makes those assessments, and especially if it's done in a quite opaque way that the substantiation is also sometimes lacking and contradicting independent assessment. So I think it would also benefit the credibility of the Commission itself to leave it to, or at least in a transparent way, involve experts with their assessments and conclusions. And yeah, I find it concerning that the Commission is always very reluctant in doing so, like we should know and we should do our own work in that sense. So yeah, what are the exact barriers? I really think it's specifically the lack of political will to be more transparent and also to rely on independent institutions or experts. Maybe because of they want to use it as a tool, they want to continue instrumentalization. Otherwise, there would be no reason why they should be reluctant. And yeah, I think they could only continue with own assessment if there would be a very clear distinction in those dual roles that the Commission has. So really separate them. That would make it more credible. But as long as it's all in one, institution where those political considerations plays a big role in the college, then yeah, it's not a healthy situation.
Thank you, Tineke. Do you know, I'm wondering if I should start doing an ASMR version of moderation and start just whispering into the microphone. But no, let's go to Florian. I realize you've heard a lot of criticism of the Commission in the last 20 minutes or so well done. But for you, what are the kind of challenges that you see to rule of law reporting within the EU?
Thank you very much. I will use the opportunity that I have the voice also to maybe react to some of the points and also to comment briefly on the report and what we were discussing so far. I think indeed the call that we should also monitor the rule of law compliance, the rule of law standards at the EU itself, so the missing chapter in a way, as it's also sometimes called, and not only the member states' performance, is indeed something that the Parliament has been calling for in many resolutions. And it's interesting to see that this call is responded on the one hand by the CEU, in the way how it is done in the report from last year, from this year, which looks a bit more at the substance, at the policies, at developments, at court cases, critically about the migration policy as such. So it's not so much a criticism about the rule of law or the rule of law report, but you criticize the policy that is being instituted at EU level in a general way, and that's very legitimate. You also have the other respondents to that parliamentary call for assessing the compliance at EU level by reports that I've also been at the launch event of the Nesepont Institute, which is an Hungarian institute, which is going, very critical more about the actors. So not about the policy or not about court judgments, but rather about where does the Commission fail, where does the Parliament fail, where does the Court of Justice in itself fail, and builds, of course, a lot on the issues that have, of course, been subject to legitimate concerns. There are a number of corruption scandals that have rocked also the Parliament. So these events are being picked on in the report of the Nesepont Institute to say, look, this is where the EU institutions have a rule of law problem. The Nesepont Institute also sees conflict of interest, for instance, by appointing as a Dutch judge someone who has been working in the Commission before, and says this as a like a conflict of interest, because how can you have worked in the Commission and then become a judge? Or it criticizes, transparency and the fact that we in the Commission rely on Transparency International, for instance, as a source to measure, like that we report on the Transparency International Index on Corruption. Of course, because the Nesepont Institute thinks that Transparency International, is not, like independent and objective. So you have those two ways of responding to the call from the Parliament, and in both instances, it is very interesting for the Commission to see how this is done, and to try to explain how we do and what we do, and that leads, of course, then to the challenges. I think if we look back, and Laurent gave a bit of the brief history of the first report when it came for the first time in 2020, it's not just the report that we need to look at, because the CEU's report, as I said, is very much looking at policies in other areas. So not about, like the fact how we do the reporting or whether something is missing in the report, but actually how do we perform as an EU in areas which are relevant for the rule of law. And there, I think it's important to see that the rule of law report as such, as we do it from the Commission side, remains one element only of this bigger picture that is also being touched upon by the CEU's report. And it's good to see the elements that have been done over the last 5 to 6 years when we started doing the rule of law report with what we have else done that feeds into this wider picture on democracy, rule of law, fundamental rights, in order to have this bigger understanding also. And there, if just to mention a couple of them, so while we reported on developments in member states, we tried to broaden the tools that we have, the laws that we have, the standards that we set at an EU level that feeds directly to the issues that we are discussing. And that's, for instance, in the area of media freedom, not only the European Media Freedom Act that was already mentioned, that is also part of the report. And I would invite you really to look into what is in this European Media Freedom Act and to acknowledge the importance that this Media Freedom Act has and the opportunities that it will be providing on actually enforcing very important aspects. There's issues, for instance, like secret surveillance of journalists in the European Media Freedom Act, regulated as hard law by the Parliament and the Council together. We have issued and adopted legislation with the Council and Parliament on SLAPP. We have an anti-SLAPP recommendation. We have a recommendation on the safety of journalists. We have a civil society recommendation. We proposed an anti-corruption directive that is being negotiated by Council and Parliament, which will oblige when it comes, and also the EU is itself part of the international conventions on anti-corruption, that we have an EU anti-corruption strategy that we need to develop for the EU level institutions on anti-corruption. We have the upcoming, and you mentioned that also very soon in 2 weeks' time, the civil society strategy that we have 2 years ago complemented or added already with a recommendation on civil society, including how to conduct structured dialogues with civil society and an inclusive process of bringing civil society into national procedures. We are coming with the Defense of Democracy package also in 2 weeks' time. And in parallel to this, of course, over the last 5 years, we have the conditionality regulation. So we have the financial tools that we have activated, also following pressure from the European Parliament. I'm not denying this. We have recovery and resilience milestones that have achieved things that have not been achieved before by any other means. This also has to be acknowledged. Of course, there are many questions, there are many problems also with this, but there have been milestones achieved that had not been done, and including milestones that directly implement Court of Human Rights judgments, which the Committee of Ministers for the Execution of Judgments have not managed to obtain over 10 years to implement. They were translated into a milestone, and they have been implemented. Again, question mark, how is it then working in practice? But that's another matter. That's not a critique of the attempt as such to try to do the good things also via the Recovery and Resilience Facility. We have the Charter Horizontal Enabling Conditions, which did not exist before, and which has also been doing its work, including, as you know, on the withholding of still a high number of funds, of cohesion funds. We did infringement action. Very often I hear that we do not enforce. But exactly in the case of migration, I think we have an unprecedented enforcement action that has been taken place with a very high lump sum and a daily penalty payment that has been issued in the area of asylum and migration. One thing, but also in the area of rule of law, we have taken enforcement action on the rule of law that has never been done before, previous to the 10 years. We have launched infringements based on Article 19. We have launched infringements based on primacy. We have enforced infringement actions that went up to €500 million of penalty payments. So don't tell me that we don't enforce. Of course we can do more, but it's not true that we don't enforce at all. That is simply not true. We also work in the Council and Parliament, again, something that has not happened before. Look back at the Council's rule of law dialogue in 2014. What were they doing? They were discussing once a year a topic that had nothing to do with the rule of law, and they felt great about it. Now we have the Council just discussing again in 2 weeks' time the rule of law situation in Germany, Bulgaria, Ireland, and Czechia. And this is when the ministers sit together, and they might sometimes be bored about it, but that's an institutional setting that they have to do, and that each presidency is driving them forward. And in 2023, the Council evaluated their new Council's rule of law dialogue, where they go deep into country-specific discussions, and they said, we want to continue with this, and we want to continue doing this on the basis of the rule of law report. There were some member states which said, no, the old model was great when we were discussing once a year on something that doesn't hurt anyone. And ideally, we should do this not on the basis of the Commission's rule of law report, but we should do this on the basis of our own member states' contribution, because the Commission, of course, doesn't understand the situation in the member states because they don't know what they are doing, and we can explain you better what is the real situation in our member states. This was rejected by 26 other member states, and they wanted to follow the approach that they have been giving themselves. The Parliament itself, and Tineke is a very strong, fervent, and important contributor on this, of course, in Parliament, is also discussing regularly country-specific discussions, apart from the big resolutions, the big plenary debates, also in the Democracy, Rule of Law, Fundamental Rights Monitoring Group, country-specific discussions, but also in other committees. And again, this is very important. In CONT, for instance, and in BUDGE, they're discussing the financial aspects of the rule of law, the anti-corruption framework, and the tools that we have to protect the rule of law. And this, again, is a very important contribution to the overall picture, which we also didn't have in the same way 5 years ago, 6 years ago, 7 years ago. And then and I talked too long, but I think it's important to try to give a bit of a different perspective. We've, of course, where we diverge on our views, we have the tools and the means and the avenues to challenge them. And that's also part of the question. Should there not be a chapter on the EU institutions? They are non-accountable, nobody controls them, they can do whatever they want. We are in court whenever there is an institution thinking, we, meaning now the Commission, that we have not done our job properly. The Parliament has brought us to the court because of the release of the 20 billion, making 20 billion reimbursable under cohesion funds for Hungary, because the Commission decided that what we had asked them in 2022 on the judicial reform, we consider they have done what we asked them. We have not asked maybe everything, but what we have asked them, they have done. And on basis on this, we released or we made reimbursable parts of the cohesion funds that were so far blocked. The Parliament disagrees. We are in court. We are defending our case. Parliament defends their case. It's one of the rare occasions where the Commission and Hungary are actually on the same side in a court case. And we will see what the Court of Justice will say. Medal case was already mentioned on the RRP funds for Poland. Again, we will fight that through. But that's actually against the Council. The Hungarian universities who can no longer participate on Erasmus, those who are controlled by public interest trusts, are equally in court against the Council because of the part of the conditionality decision that froze funds for them and forbid every EU actor to contract with an entity that is maintained by a public interest trust. So again, we are in court, we defend our arguments, because the accusations that we are too politicized, that we don't take right decisions and that we take illegal decisions come from both the, those who feel that we don't do enough on the rule of law and those who think that we do wrong things on the rule of law. Double standards, accusation come from both sides. Double standards come from the Hungarians, that we treat them more critically than any others. You say we have double standards by not, pointing the finger where we should point the fingers. Hungary went against the European Media Freedom Act and is still in court, arguing that it was illegally adopted. Hungary and Poland challenged the conditionality regulation, the legality. We won that case. And we are subject also to the Court of Auditors. And the Court of Auditors has issued a critical report on how we manage conditionality, recovery and resilience facility, Charter Hack, and also a critical report on how we do the rule of law report. And we need to respond to this, and we need to work with this, and we need to improve. So all of these aspects contribute to trying to be better, trying to improve our things, but to paint the picture that we do nothing and that we are totally unaccountable and that nobody controls anyone at EU level is simply not correct. And I hope that I could contribute in defending this impression. Thank you.
Thank you so much. I realize that many of the lawyers in the room will definitely want to pick up on policies versus laws. I could feel that coming at me. I felt it very strongly. However, it is with the great relief to my voice that I can now open up to questions in the room. So could we see if we have a first round of questions? Go ahead. Sorry, we're going to start with Sophie.
Former EPC, now senior advisor at the EPC, and also working with Liberties and Christie. I'll try to make it short, Joelle. I have 3 questions. The first one is, in the last MFF, you had the horizontal enabling condition under the CPR, you had the conditionality regulation, and you had the super milestones. And my question is, how do you want to do that in the next MFF? Is it going to be more transparent? What is planned? Because it was not very clear how the funds were frozen. I mean, there were different things that were used, and it would be good to be a bit more transparent about that. The second one is on the frozen funds. How are they going to be used? I know it's probably a political discussion, but I'd love to hear a bit more about, is it going to go back into directly managed funds under Agora-EU? Is it going to go to public authorities? What is going to happen with that money? And the third one is, how can we avoid a politicization? I think Tineke Strik said that, it would be good to have more of a, Chinese wall. But I heard, for instance, that DG Regio had a lot to say about how cohesion funds are going to be released and not DG Just. And so my question would be, how do you make sure in the internal governance of the Commission how this could be improved? And I'll stop here.
Thank you very much for the magnificent panel. I have a question to Florian. What is your definition of enforcement? It's a broad one, but one way to look at enforcement is that you actually enforce the law and the values, and the situation on the ground changes. And the examples that you gave, at least in relation to Hungary, do not demonstrate this kind of idea of enforcement. They demonstrate a different one, that you win cases, and then my university is gone from the country, and then nothing changes on the ground. Then 20 billion is released because some boxes are ticked, but nothing has changed. So it's a different enforcement. And then if you combine that kind of different enforcement with scholarship that points to a simple fact that there are actually less infringement proceedings, and we see it's incontestable, then I wonder whether you are not more frequently on the side of Hungary and the likes of Hungary than you would otherwise think.
We have a few to Florian. I also do want to come back to Tineke on politicization and maybe how we can reduce politicization. But Florian, you really do seem like you have a target right now. So let's pass over to you.
Thank you. I think on the MFF, very briefly, so we adopted that's actually one of the things that I also had on my list to say things that we have done in the sense of like done as much as the Commission can do things in terms of proposing legislation. So it's, of course, the new MFF is not yet in place. Who knows whether it comes as we proposed it. You saw also the reporting on this. But the intention in the MFF proposal is indeed to create a stronger link between the rule of law report / recommendations. At the moment, there's a reference to information contained in the report, the Justice Scoreboard, but also, of course, many other sources, and financial support, as President von der Leyen announced a year ago in the political guidelines. So that's translated into the NRRP regulation proposal. Look at Articles 8 and 9 and 22, where at this moment we try to make it a bit more predictable. That's indeed one of the points also that member states had questions about in how we manage under the current financial system, the different strands, charter hack, conditionality, the RRP funds, to follow the same process there and to have parallel and similar processes for looking at charter aspects and rule of law aspects. So we propose this. As I said, I do not know if this will come in that way, but it is in the NRRP regulation, and that certainly deserves also a separate EPC seminar to dissect the MFF proposal, and that proposal, or somewhere in the MFF proposals, is also an idea that is an indicator of what also the Parliament very much called for on smart conditionality, where it says that funds that would be withheld or that cannot be payable under any of the charter or rule of law related aspects could then, pop up funds which directly contribute to, like rule of law relevant, charter relevant other projects, including, as you mentioned already, Agora EU, which is the successor, or which is proposed to be the successor of the current SURF, the big and actually only real money that we have in DG Justice, very small SURF, but Agora EU should bring more together, different aspects as well. And frozen funds could then, be transferred into these points. On the organization or the reorganization of the Commission and how to manage the new MFF, as a small head of unit on the Rule of Law unit, I will not be able to tell you how this is going. I can just tell you that how it was going so far, and indeed, employment and regional work, because they are those who sit on the social funds and the cohesion funds, they had the capacity and the rules to enforce the questions on the Charter horizontal enabling condition. DG Budge is in charge of the conditionality regulation. As you know, the legal base for the conditionality regulation is not a rule of law base. It's not Article 2. The court has clearly said that. It's a financial instrument to protect the financial interests of the Union. And that's why the challenge of Hungary and Poland, who argued to say it's a rule of law instrument and you use the wrong legal base, was rejected, which makes it also so important that we apply the conditionality regulation very strictly. And the court has set very high thresholds and benchmarks for the Commission to prove the link between the violation of the rule of law principles and the direct or the risk to the protection of the financial interests of the Union. And of course, because of this legal base, we need to work with this. And the conditionality regulation was also not opened for renegotiation under the new MFF. So that's supposed to stay and to continue. Hungary is losing every year 1 billion euros for good under the conditionality mechanism and the regulation that is in place, because it has so far failed to implement any of the requirements, remedial measures that were supposed to that they were supposed to address. So there you have, around 6 billion frozen under the conditionality regulation, and according to the regulation, when you don't remedy within a certain amount of time, those frozen funds get lost. They go then, at the moment, back into the bigger pot. So last year, on the 31st of December 2024, at 23.59.59, Hungary lost 1 billion, and if nothing changes before this year's Sylvester New Year Day, another 1 billion will be lost again for good, not recoverable. Enforcement. We do enforcement, and we can do enforcement based on what is in the treaty. And that is infringement procedures, and for non-implementation of a judgment, Article 260, we can try to enforce that judgment. We cannot, and we are not the magic wand, and we cannot change, reality on the ground, as much as if you want to say, every national court can also not really, create the conditions that it rules in its judgment. So if we identify that a member state has breached EU law, we can do what is in the treaty, but we cannot go and change that reality on the ground. So we are within the procedure. So of course, on the Hungarian, on the case of the CEU, there was a judgment. It came at a time in which the facts have already been, put in place. And that's why the judgment came too late. So that's why sometimes also, and I know that here in the room, you're very critical of the dialogue. You say, yes, you say the dialogue doesn't bring anything, and you should do infringement actions, and you should do interim measures, and you should move very quickly.
You can do all of this at once.
Exactly, you can do all, we can only do, yes, we can shorten the procedures, and we can ask for interim measures once we are at the court. To get to the court, we first have to have a letter of formal notice, a reasoned opinion, then we are at the court, and then we can ask for interim measures. We can do that short. And we have showed that we can do this. We have shown that we can do it. So the dialogue is always, very much, pushed aside in the forum of the critical rule of law context, but don't underestimate the dialogue, because sometimes the dialogue can actually do what infringements cannot do on time. And if we stay with the example of Hungary, you knew that in June there was an attempt to have another transparency law. Mm-hmm. That attempt has so far not materialized. And if you read the press, some people say it's even thanks to some of the words that the Commission has said. Maybe not all, maybe you will deny that. But so there we didn't need to have... Exactly, that's what I said. I said also, not only. It was a very big community, around the globe that said this is a really bad idea. And this law was postponed. When Slovakia wanted to change its whistleblower protection law, taking retroactively away whistleblower protection from policemen, we made very clear that this is a blatant violation of the whistleblower directive, and we think this law has never come back since then. It might come back, but it has not come back. When Slovakia changed its criminal code in February 2024, we had, again, you will say, lots of talks, lots of discussions, no result. But Slovakia changed its criminal code 3 times in 2024 and has reverted it back, bringing it into line with the Protection of the Financial Interests Directive. No infringement procedure had, within that time span, led to the same results. That works sometimes, and it sometimes doesn't work. But I fully agree to that. But the dialogue itself is important to pursue. The Spanish Council for the Judiciary has been re-elected for 5 years in total, I think. We had a rule of law recommendation, and we had a structured dialogue. Again, we have never done that before. The Commission has never itself took the responsibility to try to bring 2 parties at a national dispute together to solve a major rule of law crisis, because the fact that the Spanish Council for the Judiciary was not reappointed led to the fact that there were no judges being appointed at the Supreme Court and led to a backlog of cases. So we had recommended, nothing happened, and then the Commission said this has to We want this to change. And we invited for the structured dialogue, and the structured dialogue led to a result that has now led to a renewal and has now led to proposals for legislative changes to the Council of the Judiciary and how the Council of the Judiciary in Spain is appointed. Together with the Venice Commission, together with many actors. But again, there was no enforcement action, there was no infringement action, there was no sanctioning, and yet there is a real-life result. This is a real-life result. That's how I try to respond.
I've never seen a man so aggressively chew gum as Laurent just now. But no, I want to stick with an earlier point that was raised on depoliticization of rule of law. We've had fantastic questions also coming in online. So I actually want to riff on Christina. Also, Christina online, thank you for thanking us. I love being thanked. My ego is massive. So, Tineke, what steps should be taken to minimize the politicization or even to depoliticize the rule of law in the EU and member states?
Yeah, it's not an easy task, of course, because it's almost an inherent development that everything that the Commission does is based on political considerations. Actually, maybe we should take a step back and really do a kind of exercise. How can we indeed create some firewalls? Because now every decision on enforcement is also being made in the college where all commissioners are there. If you think at the national level where you have a more or less independent prosecutor, you know, shouldn't we also have a different department not being subject to this political decision making? But that will require a long-term, a very fundamental review, of course. I think what could already be done now is to use the rule of law report more consistently to show to member states what are the consequences anyhow, despite political considerations, if they do not comply. For instance, with very concrete recommendations on any violations with clear deadlines and already announcing what measures will be taken if these deadlines are not met. So that would reduce the possibility that the Commission can decide differently if other interests would play a role. That would also require more transparency on why certain decisions are being made. Whether specifically decisions, of course, not to enforce or to defreeze funding. So also to show to the member states and to the audience that there are solid arguments for doing that. And for instance, on what Florian mentioned with the defreezing, that Hungary had simply met the conditions that the Commission had imposed, that was really meeting conditions on paper, this National Judicial Council, because if you look into the practice, and maybe it could have been concluded already by then, it's circumvented completely. It's not giving the possibility to really function as a kind of supervisory body or a safeguard in any sense. And I think what really hurt a lot was the way that the Commission acted after the elections in Poland. Laurent was already mentioning that, immediately saying now things will be remedied, looked at the National Action Plan. And it was very opaque. No one actually knew what was the exact ground. And that enabled, of course, Hungary to say, look, this is all political. So I really hope that the Commission has drawn lessons from that. And even if Orban will be defeated in April, there will be a very careful and transparent procedure if certain steps are being taken to unfreeze funding or take other measures to support a new government. So, you know, even if there's no really fundamental change, a lot of things could already be improved in order to show that there's a solid and consistent way of using the instruments.
Thank you. I suggest another round of questions in the room. We have 4 that immediately jumped out, so we can start in the first row up here. Oh, right there. Yes, go ahead. Yeah, definitely.
Well, first of all, thank you very much for this great panel. And my name is Osama Arshad. I'm from the European Network of National Human Rights Institutions. So I wanted to quickly connect to the point on the MFF. And I had two questions, one for Florian, one for Laurent. So for Florian is, recently there was also a rule of law semester proposed in the parliament where the Commissioner McGrath said that the member states will need to prove their commitment to rule of law improvements in line with the Commission recommendations in the rule of law report before being able to sign the regional and national partnership agreements, if I understood correctly. I wanted to ask in that regard, how would this look in practice, first of all, and how will the Commission potentially, if this is approved, assess the member state submissions on showing their commitment to the rule of law or alignment to the rule of law? And secondly, also connecting to this point a bit with Laurent, who also intervened in the rule of law semester proposal. You also mentioned during that intervention that you noticed that there's a causal disregard of undermining the rule of law in countries where things are relatively stable, and that you notice a trend where internal and external lawlessness is rising. So how could you see potentially the role of the EU Commission or the EU institutions in general to prevent rather than just reacting to these trends and these issues, and if you see any role for these institutions? Thank you very much.
And I also thank you as being a model question asker. You introduced yourself and you had succinct, interesting questions. Let's all follow that example. I think we have Barbara in the first row, and then we'll come back. There was one here and then one there.
I want to ask you about your rule of law wish list in terms of this division that Florian mentioned. So division between the policy and kind of eternal critic to institution itself. Could you think about any potential amendments to the EU primary law that would solve some of the rule of law issues that you mentioned you could recognize? Is there anything that should be changed in the treaties, in the charter, that could actually improve the situation? And here is something which is not a question, rather a disclaimer, which I cannot comment. I just want to mention that the Transparency International was one of with whom we cooperated with this report, and we're super grateful for that. Thank you.
And I think there was just here, yes.
Thank you very much. I think it's a really important missing piece of the reporting, this new report. As I'm Kirsty McCourt from the Civil Liberties Union for Europe, and we will be publishing next week actually a gap analysis which looks at the Commission's last report and the reporting by civil society. And I won't give away too many parts, but we do see a lot of gaps, and particularly this year we're focusing on the implementation of recommendations that are made year after year after year, and we don't see any progress, and we don't see any consequences for that lack of progress. My question here is also around the EU's own legislative processes, which I think we've seen, and from my skim reading, I don't know whether it's in here, but the unpredictability now that has kind of set in making EU legislation, particularly, for example, looking at the CSDDD and now potentially around the AI Act and other legislation. And this happened both in the Council with last minute changes before the CSDDD was adopted. So that was the kind of first unpredictability of the lawmaking process, when it had already been, the general approach had already been agreed, all the votes were already done, and then things were added at the last minute. And then what we see now with these omnibus proposals, that with very little consultation and totally sending us back to zero and relaunching the legislative process. So yes, my question to the authors is then around what dangers we see for the legislation process itself at EU level. Thank you.
I think I spotted another question. Yes, just over here. I really am starting to whisper into the microphone.
Thank you. I'm Alexander Wies from Transparency International EU, but this is more like a personal interest question on migration and the rule of law. So last year, like in December, there was this communication by the Commission, basically reminding or one could also say egg on the member states that they basically telling them that they could use the general derogation clause under the TFEU Article 72 to set aside secondary EU legislation. To the authors of this of the report, do you think this is a concerning development, or this is general, or this is simply, recalling, a hierarchy of norms in the EU legal order? And do you think we will see this in other fields as well, that the Commission is saying, hey, if you have issues with secondary legislation, please be reminded that you can always derogate in the interests of national security, even though the court until now has never accepted this, as far as I can tell. Thank you.
Good question. I think we should start with the authors, so Sarah and Laurent, and we'll come back to Tineke and to Florian. Sarah, could I start with you?
Sure. Thank you so much for a very, very interesting question. Yeah, of course, this is part of the whole kind of rule of law backsliding, which is already so low in terms of migration that it's just part of not only saying that migrants basically are subjected to double standards, but there is no standards when it comes to migration anymore. And that's interesting that you mentioned the many infringement action in the field of migration, because the most important issues in terms of migration, like we haven't seen the Commission stepping in. On the contrary, the Commission is basically like opening a lot of basically ways to member states just to avoid like abiding by human rights and basic norms. And so, yeah, this is definitely one of the worrying a kind of interesting case. But here, just like 100 meters from here, we have the Belgian government for 3 years, which is saying that it won't apply like the reception directive after like thousands of judgments by the Belgian courts. And where is the Commission? Where is the Commission? And it's kind of interesting because we see, like, even in the non-problematic rule of law member states, like a clear rule of law backsliding when it comes to migration, and the fact that the Commission is not reacting like at all is a sign of a green light, but probably because what the Commission is doing regarding migration is problematic as well. So it's kind of a self-reinforcing loop in terms of just absolutely undermining all the basic standards when it comes to human rights. Like in a few days from now, like on the 2nd of November, I think, Italy will renew its memorandum of understanding with Libya. And again, like the Libyan official will be invited at the table here, and more training will be provided to the Libyan Coast Guards, and all of this like is well known, of course. And we have reports of the human rights violation like in Libya by the Libyan Coast Guards, but it seems that it's not a problem at all. So I think it's also a question of when we speak of enforcement, it's also a question of choice and priorities. And here is the politicization. And I think we see it very clearly in terms of migration. And so the question is, who is next, right? And I think this is an important question because first migrants, but we clearly see, as Laurent explains, that we see a gap between, on the one hand, practice, and on the other hand, like what is the discourse on the rule of law. And I think that here we need to be extremely careful.
No.
I'm going to answer the question, but just I'm not going to attempt to answer many of the points made by Florian, because that's actually, I'm going to answer them in my next article. And essentially, I also wanted to acknowledge and thank Florian for agreeing to speak at this event, because he knew it would be essentially kind of at the center of the criticism. And in a way, perhaps, Florian, I should clarify that I do spend a lot of time criticizing the Commission. Perhaps less so in terms of the Council, even though my criticism in terms of the Council's inaction is worse. But I still have hope. I'm criticizing the Commission because I have hope for the Commission when I have no hope left when it comes to the Council. You have mentioned articles. I could go on with actually the way the Council's rule of law dialogue is completely useless, toothless, counterproductive, and the way the Council has actually interpreted Article 7 proceedings in breach of the treaties. But this is not the topic of discussion today. Regarding infringement actions, however, I just wanted to react very briefly. Actually, so the problem is not that the Commission has launched rule of law infringement actions. I never said that there was no enforcement at all. My problem is that the situation where there was no infringement action and where there was an infringement action but without interim measures. And here, perhaps I promised you a bit of rule of law gossip. No one has asked me for some rule of law gossip, but I have some regarding the CEU here. And actually, I cannot prove my case, but perhaps some people have evidence, but I don't think that's possible. In the case of the CEU, so the Commission was bold in this case. You cannot deny that. First academic freedom infringement action ever in the history of EU law. And the leadership came from Timmermans and DG Justice. This was the perfect case, textbook case, to ask for interim measures, because without interim measures, then there was no way the CEU could sustain the onslaught of unconstitutional measures, by the way, as well, in addition to violations of European rule of law standards. And here is the bit of EU rule of law gossip. I was told by a source that, in fact, there was a request within the Commission to apply for interim measures, but it was shut down within the Commission on account that the Court of Justice would never agree to grant interim measures in an academic freedom case. So I did mention that the EU institutions are not monolithic institutions. So in the case of the Commission, and I'm not expecting Florian to react, but clearly, like in the Council, you have pro-rule of law actors and those with more conservative, if not openly anti-rule of law views. It is our mission, I would say, as rule of law academics, to make sure that the pro-rule of law actors in the ecosystem are essentially presented with sound legal assessments and a reminder of their legal duties. So in the case of interim measures, there is one pending infringement action which screams for interim measures. It's the pending anti-NGO legislation originating from, again, the Commission did the right thing here, except didn't go all the way. There was the best textbook case of infringement action, the best ever I have seen in the rule of law world, in the rule of law field, was the one regarding the Supreme Court of Poland, which was under threat of a immediate purge. And then we had the quickest, the best package infringement action ever devised. And that's the model to follow, I would say, if I could provide some advice to the Commission. So it's not the few actions initiated by the Commission which are the problem, it's all the instances where there is no action or not sufficient action. And so that's my kind of a broader reaction. I was asked a question about systemic threats and to the rule of law and systemic violations of the rule of law, and I can give you actually a quick answer. With Professor Bard, and we published a study on behalf of the European Parliament on the EU's rule of law textbook, what am I saying? Toolbox. And so it was published in 2022, and then we identified a number of shortcomings when it comes to annual rule of law reporting. And essentially, we explain what can be done to actually better assess systemic backsliding trends. I can give you a concrete, very practical suggestion, which would actually improve the annual rule of law reporting. You include in each country chapter the rule of law score of the country for the past 10 years, and you derive this score from VDEM and World Justice Project data. You have the data here. The Commission has agreed in some circumstances to use non-EU data. And then you put this at the top of the page before we see a summary and recommendation. And then you will see immediately which countries are backsliding and how long they've been backsliding. If you had included this kind of data above on the cover page of the Hungarian report or the Serbian report, then you will see automatically you disconnect between what is being described and the overall trends. If you read annual rule of law report, you have no idea of whether a country is actually backsliding and systematically or not systematically threatening the rule of law. Then the last question I can remember was the rule of law wish list. So assuming that we could make some treaty changes, I would say legal standing rules, and that would be my first wish. And my second wish would be to actually give the power to launch infringement actions to another institution. So to have essentially two guardians of the treaty to kind of a check and balance situation where, for whatever reasons, the primary guardian of the treaties is not in a position to launch infringement actions. We could potentially, why not, empower the EU Fundamental Rights Agency with the faculty of bringing infringement actions which have been described by the Commission itself as Article 2 infringement actions, so EU values infringement actions. So give them the power to bring infringement actions. That would be a treaty change required for this. currently, member states can also do their job, but they don't. Then, in defense of the Commission, they hide behind the Commission. So this has been tested. It hasn't worked. Member states do not want to sue each other, apart from very exceptional situations. And then, essentially, we need kind of a third actor with the power to launch infringement actions. And if you improve or make it easier for association of judges to bring direct annulment actions, and then you have a third actor, then the balance is, the system is going to auto-correct itself in a situation for whatever political, geopolitical reasons. There is a reluctance from the main EU institutions to actually enforce rule of law requirements. And one last point, we mentioned the Parliament versus Commission litigation. But if the Parliament had not sued for whatever reasons, then essentially you are looking at a potential situation where 10.2 billion euros have been unlocked on the basis of a legal assessment which may not sustain scrutiny. And in fact, what we have seen in the case of Hungary is that the rule of law situation now is actually worse than in December 2023, and that can be objectively demonstrated by one example which was already mentioned in the discussion. Currently, Hungary is in a structural violation of Article 267 of the TFEU. It is impossible. The national judges in Hungary have been dissuaded and are not able actually to implement rulings of the Court of Justice issue on the back of Article 267. I mean, Tineke was mentioning this. And this issue is actually mentioned in the rule of law report by the Commission. And here the wording is actually as close and as clear as you can essentially be in the context of the annual rule of law report. But then my question would be, if you identify something which is like a structural violation of EU primary law, and it is actually highlighted in a report, this is not a time for dialogue. This is a time for enforcement. This is one of the two stepping stones on which the EU legal system is based. We're not talking about a disagreement about policies here. And I'm not asking Florian to react. What I can tell you is that people in the Commission are aware of and would agree with what I've just said, but essentially the Commission, whether we like it or not, is part of a broader political ecosystem. But what we're facing, and this is a more structural question for all of us, the institutional framework from the 1950s, where the Commission was the primary guardian of the treaty, is it not time for a change when the Commission has become very much a political actor, first and foremost, rather than the guardian of the treaty? Can we have an increasing politicization of the EU institutional framework while maintaining what should be independent exercise of what I would call regulatory functions? Can we have a Commission both as a political actor and as a regulatory enforcer? Or is that not too schizophrenic to ask of a single institution? So this is a broader constitutional question where essentially we have to look beyond the rule of law field. This is actually an issue across policy fields. Can we have a political actor also in charge of enforcing when the political actor is directly, for reasons I'm not going to go into, might be tempted to actually trade non-enforcement to achieve political goals? So this is a broader constitutional question, which I'm not going to try to answer.
You should have offered chewing gum to Florian. I am very aware that I'm taking away from your lunch. So before we give final words to Tineke, Florian, would you like any thoughts on those questions?
Yes. I think on the RRP, on your question, because I want to come back also, as it was such a good question, that you also get, that we are not carried away by the attractiveness of the wish list, for instance, but stay on the ground of the RRP proposal. So I think, as I said before, first of all, we need to see if this is really going to be, if the outcome, this will be 2 years negotiations, will be as proposed. So how this will work in practice right now, I can tell you, because we don't know if that is actually what will be the practice in the future. I think what you can look at a bit is how it was been done so far under the Recovery and Resilience Facility, where member states had to come forward with plans for, projects, investments that respond to the semester recommendations, the country-specific recommendations in the semester. And because we had, and now goes the link to the rule of law report and the rule of law policy, because we had semester recommendations, so that's actually the economic wider context of economic coordination after the financial crisis of 2008, because we had luckily some member states where we had recommendations on the justice system, most often on the efficiency, but also on the independence in the case of Poland and Hungary. So we had recommendations that explicitly, semester recommendations by the Council on the proposal of the Commission, which explicitly mentioned the independence of the justice in those two member states. And we had anti-corruption recommendations. Where we had those recommendations, the Commission could ask the member states to include in their plans for the RRP, which was Corona-induced, milestones and projects, investments that would respond to those challenges identified. And then member states were coming forward. They said, look, we could do this, we could do this. And the Commission was saying, yeah, that would be good, but maybe can you also do that a bit more? So it's a bit of it's not an obligation. The only obligation was that member states respond to a significant subset of European semester recommendations, and thereby then, have a nice, good, list of actions that would enhance competitiveness and economic growth, etc. That was the logic of the RRP. But it was possible to use that also to advance, as I said before, justice reforms, rule of law reforms, because they were in the semester recommendation. That basic idea, and then member states agree to the plan, they propose it, we agree to the plan, Commission, we recommend it to the Council approves the plan for all the member states, and each step then, then member states implement the projects and they send us a bill. They say, I have done milestone 5 and I have done milestone this, this and this. Now I'm eligible for a new payment of funds from the Recovery and Resilience Facility. The Commission assesses this payment request, and we go to the Council. Again, we say, we think Member State X has fulfilled their milestones and targets. Do you agree that we can pay out of this pot of money? And then Member States either say yes or no. And this is how, in a way, it works for the RRP in a very simplified way. And that is a bit the model how, I think the idea is that the new MFF could work. Basically, but with the difference that we can go directly to information issues, positive or negative, that are, contained in the rule of law report, in the justice scoreboard, in the digital decade, in the semester report. So a wealth of documented and existing material where member states can say, actually, good. And this is going to be, and now I'm looking forward, this is going to be very interesting if it works like this from the rule of law report perspective. Because at this moment in time, member states would like to get as few as possible recommendations. And we have lots of discussions with Germany, for instance, how we dare to make a recommendation on resources or salaries of judges. Ooh, they don't like this. And I'm German, so I know. But actually, in the future, there could be an interest of member states to get more recommendations, because that would allow them to access budget. And maybe if we have a structural issue, like not enough judges, too few payments, there could be a possibility maybe to get EU funds, not only to build courthouses and to buy computers and laptops, but actually also, to have, funding for more judges. And that would, of course, be super interesting. And that would, again, be a real-life change on the ground without any infringement.
If those are not fake judges.
If these are not fake judges, of course. And that will be then depending how we formulate the, the milestones and the recommendations. But this is, in a way, how the basic idea is. So it's not only, and this is also important to understand, it's not only is, if you don't do this, you don't get money. But actually, if there's something that we all agree would be great to have and do, but in the current context, the member states doesn't have enough money, cannot afford to have a new, IT system or enough judges or efficient procedures. There's the EU money that could help implement that. So it's not only a negative, stick approach, but also a carrot. Yes, an incentive. The wish list. 2 seconds. The wish list. I love the wish list. Next week, there is the enlargement package coming out. And as part of the enlargement package, there is what is called the pre-enlargement policy reviews. those who had the patience to read the political guidelines of President von der Leyen until the very, very last page, and that's page 32, I think, saw that there was an invitation or like a 100 days initiative responding to the European Council of June 2023, to say the Commission should check whether actually our own setup and our treaty and our everything is ready for an enlargement that could involve, potentially, let's name it 32, 33, 36 new member states, also on the rule of law. And this pre-enlargement policy review is not an enlargement document. It's actually an institutional document, and it's super interesting. And the Commission will present it. I have not seen it for a while. I don't know if it will be as interesting as I would wish it to be, but it's a good opportunity again for all of us, for the Council, for the leaders, for the Parliament to discuss whether the good ideas are contained therein, or whether we say everything is fantastic as it is now, which might not respond to the wish list. I could also imagine it would be great to have maybe pilot projects at the Court of Justice where we could bring systemic cases without going one by one, but going with one case that could be transferable to other cases in the rule of law. That would be great, because this would allow us to address systemic issues. Easier access, I think also the Plowman, what you mentioned before, could be an interesting case that would require treaty change, of course. Maybe we want to make Article 7 a bit more bitey and a bit more manageable. I mean, there's a very long wish list that we can engage in academically, and we all have our thoughts. But this would be indeed some of the points to make also infringements faster. This would require some changes at the treaty or the statute of the court level. That would be great to have more bite. But at this stage, it remains a wish.
And final thoughts to Tineke.
Yeah, it's really an honor to stand in the way of to the lunch for the participants. So I will really be brief. Just to refer to the last things that Florian said, it's really good, of course, to do this exercise on how the treaty could and should be changed in order to have a stronger way of upholding rule of law. But let us not distract ourselves to the possibilities that are already there at the moment on the table. If I think of systematic infringement, Article 2 values infringement, it's all possible. And I think dialogues with the member states also work best if there's a real tangible threat of taken action by the Commission. So that would really incentivize member states to cooperate constructively. Also on the Council, you can change Article 7, but after all, it boils down to the lack of political will that nothing is being done. And that will not change even with the change of the treaty, which will be very difficult to reach, I'm afraid. So let us not distract to that. Of course, it's always nice to do these kinds of exercises. We need to do it, but focus also on what should be done right now. And I would also say not enforcing gives such a wrong message to other member states. I mean, Sarah mentioned the example of Belgium. Immediately that leads to a discussion in the Netherlands. Why should we then host all the single male asylum seekers? So it really leads to a kind of race to the bottom. And this is, of course, very much also infringing upon the required mutual trust within the EU. And on asylum, you can see that. We then place the ball in the corner of the courts. We'd have to decide if a transfer is responsible, if it doesn't infringe upon the fundamental rights of an asylum seekers because of a lack of safeguards in that other member states. So we should not do that, because courts are already under heavy pressure. And that means that we all have to take our own role, take our own responsibility in this whole institutional balance. And in that sense, I would also say the Parliament also has a lot of work to do there. Also, if it comes to the quality of legislation, of decision making. I think there the Parliament should be less hesitant to use its power, to use its prerogative as a co-legislator and really demand from the Commission, for instance, that impact assessments are being made, that we have evidence-based proposals and evidence-based procedures, and also the example of omnibus was mentioned. I mean, Parliament is going along with such fast-track new procedures, and there I think we should stand much stronger, because we can only break this cycle of Commission, Council deciding on everything if we make sure that both the Court and the Parliament also will and can take their own role. Thank you.
Thank you so much. And now, as my voice has entirely failed, could I give huge thanks to the panel, both online and here in person. Thank you so much to the EPC for hosting us, especially in giving me tea. Also, thank you to all the contributors to the 2025 report. For everyone in the room, please do pick up a physical copy or one online. And finally, thank you so much to everyone for coming. Thank you so much to Stiftung Mercator for funding us. I'm sorry I did not take notes on who I should be thanking, but thank you so much to our funders. Thank you to EPC. Thank you all. Please go have lunch.